I will also, at the end of this, provide my Google Voice number. So part of what we definitely want to encourage for tenants. So the second part of this presentation is going to be regarding eviction expungements. So like Christina said, we're open, definitely willing to help. So I would love for tenants to reach out to me and, talk to me, about the possibility of being eligible for our services, being eligible for expungements, or if tenants are just dealing with, COVID-19 related eviction issues, housing issues, we want to hear from them. We want to know what's going on out there. So I'll share that information so that people can call me. No guarantee that I'll always answer, but they can leave a voicemail and I can guarantee that I will follow up with them whether or not we are able to provide assistance. So share that at the end. So I'll just kick off with, the big distinction, right? Like I was mentioning before, it's not uncommon for tenants to confuse these two right here, the termination and the eviction. So again, the termination is the first step in the process. And there are certain elements that it needs to have. It needs to be written, and on top of that, it needs to, contain certain things. If it's curable, if it's a curable notice, it needs to describe a cure by date, how somebody can cure it. If it's in the case of a non-payment of rent notice, obviously it needs to tell you by when you need to pay it, how much you need to pay in order to have it cured, things of that nature. It must also be properly delivered. So Chapter 90 very specifically outlines what proper delivery of a written notice is. So it includes, either personal delivery, mailing it to the tenant via first-class mail, or if the rental agreement allows, it also allows for both mailing and posting it at a designated location. So for example, the front door of a tenant's unit or something along those lines. But again, for that third one, you need to have it in the rental agreement. And so the basic purpose of these is, right, to notify the tenant that the landlord is ending the lease, but it will also typically identify why a tenant is in violation of the lease, and in most cases a deadline to resolve the issue. So again, with a non-payment, by which day you can pay. If it's, we'll get into the specific termination notices, so I won't get into the weeds, but one of the more common ones is what we call like a 3014. So that's for minor violations of the rental agreement, and those are usually curable for that first notice. Another important thing to kind of note is, these don't show up on a tenant's eviction record. A lot of tenants seem to think so. It's not going to, be a part of a background check when you apply for housing in the future or something like that. But the important thing to consider is that, as many renters know, during that application period, it's not uncommon for them to ask for the contact information of a previous landlord. So it might come up as part of a bad reference. So that is something to consider. And then lastly, they don't always lead to an eviction. So like I've already mentioned, some are curable. And yeah, that's that. And then in terms of eviction, so these are, filed in the court. They can only happen once a landlord has issued a termination notice, and has given, the tenant a proper amount of time to, cure it, or, it can't happen until the tenant hasn't complied with the deadline noted on the termination. So if I get a notice of termination from my landlord right now saying that I need to be out by May 31st, they can't, go to court and file an eviction against me on May 28th just because they suspect that I'm not going to be out. They have to give you the proper amount of time to, if it's a curable notice, to cure, and if it's not, they got to give you the proper amount of time to move out by the deadline stated on that notice. And they require the landlord and the tenant to appear in eviction court. So, we'll get into the nitty-gritty in the details of the eviction process, but that starts with, that first appearance. So tenant will get a court summons and go from there. And then lastly, the important thing to note is that these do show up on the tenant's rental history and eviction record, even if they are dismissed in the tenant's favor. So that is something that's important to know. There is an asterisk there, and the reason that it's there is because it is important to note that landlords are prohibited from, during the application process, from considering an eviction that was dismissed in the tenant's favor or that resulted in a general judgment of dismissal. Yeah, that's something important to consider. Let's see if I can skip. There we go. All right, so now we'll get into some of the different types of terminations and evictions that tenants can come across. So the first of them I'm going to note are no-cause evictions. So you can't talk about no-cause evictions without talking about Senate Bill 608, which was passed last February. So Senate Bill 608, for those of you that don't know, did two very important things. First of which we will not be discussing today, is it imposed a cap on rent increases in the state of Oregon. And then the last thing, and more pertinent to today's presentation, is it imposed a limit on no-cause evictions. So under these new laws, the only times that a landlord can now end your tenancy without a reason are during the first year of your tenancy, if your tenancy is month to month, or you had a lease that was for less than 365 days for less than a year. Or there's this exception for smaller time landlords. So if a landlord lives on the property and the property has only 1 to 2 units, so common situation, a landlord, that rents out a room in their home, and the tenant rents out that room, or they own a duplex and the landlord lives in one half of that duplex and the tenant lives in the other. Those are exceptions for these smaller time landlords. And so the amount of notice that they have to give kind of varies depending on where you are in Oregon. For the most part, in most cities, it's 30 days during that first year. After the first year, they have to give 60-day notice. But the important thing to note for anybody that falls under this exception is that, unfortunately, no-cause evictions are still very much a possibility after that first year. And then for Portland, Bend, and Milwaukee, fortunately, it's a little bit more time for tenants. It's 90-day notice that's required in those circumstances. And then the other thing that, where did I go? There we go. The other thing that SB 608 is that it created these landlord-based terminations and reasons for terminating a tenant. So there are 4 of them to note. So if you've lived in your home for a year or more, it is still possible to, unfortunately get your lease terminated for something that you didn't really have any control over. So if the landlord intends to either demolish the unit or use the unit for something other than the purpose of a residence. So if, let's say, a tenant, rents out a home, a single family home in Portland, and the landlord decides that they want to convert it into a coffee house or something of that nature, that might be a basis for giving a tenant a landlord-based reason notice. If the landlord intends to make repairs or renovations to the unit, but they deem the unit uninhabitable during the process of those renovations, it's unfit for occupancy. That's another reason. If the landlord or the landlord's immediate family member plans to move in, it is important to note that immediate family member is defined under Chapter 90. So a landlord can't just go willy-nilly saying, "Oh, my best friend is my brother and he's moving in." No, it's specifically defined, so it's important to note. And then lastly, if the landlord has sold the unit to someone who plans to move in. So for any 4 of those reasons, if somebody gets a termination notice for those, that notice needs to give them 90 days notice. And the notice needs to state the landlord-based reason, and it needs to give supporting facts. So there's a debate about whether, how specific that needs to be. This is fairly new, so haven't come across too many, but yeah, in essence, it needs to, kind of explain why it is that they're giving that termination notice, right? And then very importantly, tenants that receive this termination notice are entitled to relocation assistance. And that relocation assistance needs to be delivered to the tenant with that notice of termination, basically. So at the moment that they get that notice of termination for these landlord-based reasons, the landlords need to give them relocation assistance in the amount of 1 month's periodic rent, basically. So if rent's $1,200 a month, that tenant should be getting $1,200 in relocation assistance from the landlord. And it is also important to know while I'm on that, that in the city of Portland, that amount might actually be a little bit more under the city's relocation ordinance as well.
So I'm going to briefly jump in here and talk about the different types of for-cause termination notices. So the notices we just spoke about before were all considered no-cause notices. Even though the landlord reason notice is a reason, it's still no fault of the tenant. So those are all considered like no fault, no cause notices on the tenant side. So there is a list of notices that a landlord can give a tenant that are for tenant allegedly violating the rental agreement. The most common one we see in the vast majority, like over 75% of eviction cases in court, are non-payment of rent notices. The most common, there's actually 3 different kinds of non-payment of rent notices that a landlord can give, but the ones we see, by and away, the most common is a 72-hour notice for non-payment of rent. That can be given basically on the 5th day, the 8th day after rent being due. And so that is a curable notice, meaning it says pay the rent within 72 hours or move out in 72 hours. But the important thing to note of that is it can't be given until 8 days after rent is due. The next kind of notice is a 30-day for-cause notice. Again, this is a curable notice, meaning it's for some kind of lease violation. It says to the tenant, you've violated the lease in this way with specific facts, so the tenant can understand what the alleged lease violation is, and you have 14 days to fix it. And if you fix it within 14 days, you either pay the damage bill, stop having the loud parties, clean up your dog's poop, whatever it is, then you don't need to move out. And then the next notice here on the list is the 10-day notice for repeat violation. That's kind of related to the 30-day notice in that a tenant, if the same or substantially similar type of lease violation that was alleged in that 30-day for-cause notice, if the tenant does it again within 6 months of that 30-day notice, the landlord can say, okay, you have to move out in 10 days, and they don't have to have the right to remedy. So if you have a 10-day notice, but you haven't gotten a 30-day notice in the last 6 months, you probably have a defective 10-day notice, meaning they can't move forward on that because they have to be able to prove both the 30-day notice and the 10-day notice if you were to fight it in eviction court. And the lease violations have to be essentially the same or very similar. A 24-hour notice, this is usually pretty extreme conduct, violence, pretty severe in property damage, like intentionally trashing a unit, threats of significant and imminent physical violence or actually causing physical violence to others. And then the last one is a 10-day pet violation notice, which is you have an unauthorized pet that was not approved under a rental agreement. So either remove your pet within 10 days or you entirely move out within 10 days. A lot of times we see this come up when people do have service animals or companion animals that they didn't get authorization for by the landlord. Super common, obviously it's always a good idea to get that approval by your landlord before you move in. But if you get this notice and it is a service or companion animal, you can always make that reasonable accommodation request to have the landlord approve your pet or your assistance animal, even though it is there's a no pet policy when you get that notice. So for all notices, there's certain requirements under the law. They always have to be in writing, and that's like a piece of paper, right? Not a text message, not a phone call, not an email. It has to be an actual piece of paper. It has to give you the right amount of time to move out. So the timelines we outlined here, 30 days, 10 days, 24 hours, 72 hours. And it has to be sufficiently clear and specific. So you have to understand, like it has to say how much rent you have to pay. The rent amount has to be correct. If it's not correct, it's technically a defective notice and you could challenge it through eviction court. The lease violation they're alleging you did has to be sufficiently explained to you so you can understand what they're alleging. In terms of the amount of time to move out, if a landlord personally hands you the notice, it's effective the minute it's given to you, and it starts running at that point in terms of calculating the timeline. If the landlord mails it to you, they have to add 3 days for mailing to allow the mail to get there, and it has to be mailed by first-class mail. So if they try to mail it by certified mail, that's bad notice. And if they don't add the 3 days and they mailed it to you, that's a bad notice. The one exception is if your rental agreement allows it, the landlord can post the notice on the door and give it to you in the mail, and it's effective the date it starts running the date it's posted. But that has to be a provision in the rental agreement. And in terms of curable notices, it has to give you at least one example of how you could cure your termination notice. So, pay this bill, stop having the noise disturbances. It doesn't have to be the only cure. You could find another way to cure it if you can come up with another way. You just have to give a potential example. Okay, next slide. Thanks, Adele. The other new type, this is another creature of Senate Bill 608 that did not exist as of last year, but there's this 3-strike, we call it the 3-strike notice. So now landlords can also terminate the rental agreement at the end of a lease term. So this is for fixed term tenancies. If there's been 3 or more lease violations within the last 12 months. And so I think of this as kind of like for cause light. They don't have to have, they don't have to necessarily have given you the opportunity to cure it at that time. They just need to give you a written warning at the time of the violation to say, hey, you violated your lease. If you continue doing this and it happens 3 or more times, we may be able to terminate your lease at the end of the tenancy. And so if a landlord chooses to do that, they have to give a 90 days notice prior to the end, the date that the lease agreement terminates, saying we're terminating you based on these, 3 past lease violations within the last year. They have to be sufficient to specify the lease violations and provide supporting facts. I think it's going to be challenging. We haven't seen many of these come up yet because of the timing of when these protections rolled out. And because of now the court being closed, we're not seeing eviction cases going to trial. So we don't know how this is going to all pan out for tenants. But my concern around these 3-strike provisions is that, I can barely remember what I did a week ago. I'm not going to remember the details of a lease agreement they're alleging I did 10 months ago, right? Whereas the landlord clearly is going to be able to document it, paper the file, have all the evidence they need, but I'm not going to remember what it was. I'm not going to have gathered my, talk to my neighbor and they're not going to remember it either. So just have a little extra caution when you get these lease violation notices, because essentially it could be an indication that at the end of your lease term, they're going to terminate your tenant. And so in terms of the eviction process, the way I envision it is kind of running in 2 tracks. So the first track is if it goes to trial, and the second track is if there's some kind of stipulated agreement. So we'll do the first track first. And the reality is that very, very, very few, probably less than 10% of evictions go through to trial. So it all starts with the termination notice, like Mateo was saying. A tenant receives a termination notice, either posted on their door, handed to them, or in the mail, that tells them you violated the rental agreement in some way, or you didn't violate the rental agreement because you need to move out. And then if the tenant either doesn't cure or stays beyond the period of the termination notice, the landlord can then file it with the court. And that's when an eviction case officially starts. And that's when it becomes on somebody's record, on their court record. And so in Oregon, they're called FEDs, which is forcible entry and detainer. And by statute, the tenant is served with a summons for court within 24 hours after the eviction case is filed. So the tenant will find out about it very quickly. The summons will include a first appearance court date, which is the first time the tenant will need to go to court. That is usually held a week after the landlord files their case. And that's not the trial date. That's just simply a date where all the tenants and the landlords on the docket for that day all go to court at the same time. They're all set for 9 a.m. At least in Multnomah County, they're all set for 9 a.m. The judge goes through, calls all the names, sees if everybody's there. If the landlord isn't there and the tenant is there, the case will be dismissed in favor of the tenant. If the landlord is there but the tenant isn't there, the case will they'll rule in favor of the landlord, and the landlord automatically wins. So obviously very, very important. If you ever get anything with court, even if your landlord says, oh, don't worry, I'm going to dismiss it, go to court. You don't want to miss it. You want to make sure it gets dismissed or it gets resolved in your favor. And so at first appearance, the judge will say to everybody in the courtroom, okay, if all parties are here, go out in the hallway and see if you can work out an agreement. Vast majority of cases get resolved through an agreement in the hallway. And the agreement can pretty much be anything, any of the issues that are kind of, are unresolved between the landlord and the tenant. Oftentimes it's payment plans, oftentimes it's agreeing to not do ongoing lease violations. There is some limitations though, in terms of what the agreement can contain and how far out it can go. I'm going to talk about this though after, because we're talking about trial. So say the landlord and the tenant don't make they can't reach an agreement. They just, you know, tenant says, no, I know I have a good defense. This is a bad notice. I'm going to move forward. You either dismiss the case or we're going to trial. That same day, if the landlord says, nope, we're moving forward, the tenant would have to file an answer with the court by 4 p.m. that day. There is a filing fee associated with filing an answer with the court as a tenant if you're being evicted, which is outrageous, right? But there is fee waivers if you're low income, and the court won't charge you for that money, or at least give you the option to pay it later. And then once an answer is filed, the trial is set within 15 days. By law, it has to be set within 15 days. Usually in Multnomah County, they're set within about a week, unless there's attorneys involved and the attorneys want it scheduled farther out. So it happens all really quickly. And so if at the trial, if the landlord wins, they immediately get what's called a judgment of restitution. This is kind of the eviction judgment that shows up on the tenant's record as having been evicted. And the tenant is required to move out in 4 days. And so from start to finish, you know, the big takeaway here is that, like, case is filed, trial usually happens within 2 weeks, and then move out date if the tenant loses in 4 days. So it's super expedited process, right? And then if the tenant doesn't move out within those 4 days, the landlord can go and get what's called a writ of execution, which is basically when the sheriff comes and forces the tenant to move out and changes the locks. If the tenant wins, hooray, a judgment of dismissal, meaning the case was dismissed in the tenant's favor, and the tenant gets to stay. And whoever wins in an eviction case is required to pay the losing, no, reverse that. Whoever loses an eviction case is required to pay the winning side's court cost and any attorney's fees. So there is some risk to tenants in terms of financial risk moving forward, not only about getting the eviction, the risk of getting an eviction on your record and knowing how hard it is to find subsequent housing with that on your record, but there's also could be a financial risk in terms of having to pay the court cost. And if they have an attorney, and most landlords who go through an eviction will have an attorney, their attorney's fees. So the second track is when a case settles, and that's kind of where I was going a minute ago. So we're going to jump to the step 4 stipulated agreement, which is what I was talking about when you're out in the hallway, you're working out an agreement with your landlord. The limitations on the stipulated agreement are that it cannot require any payment plan or agreed behavioral agreements beyond 6 months from the agreement. So basically the tenant's on the hook for 6 months. They can't agree, you know, to a payment plan that goes out 12 months, or they can't agree to saying, I'm not going to have loud parties, or I'm not going to have, you know, this dangerous person over in my unit for the next, you know, 8 months. It's limited to 6 months. If the tenant follows the agreement, that's great. The case will be dismissed in 1 year, which means that there's an open eviction case on the tenant's record for that entire year that the case is kind of, you know, before it's dismissed while it's being monitored. There is a provision in the form agreement that the courts use that the parties can, you know, write out what they are agreeing to and sign it, that has an earlier dismissal date. So I always encourage tenants, ask that the case be dismissed, you know, within 2 months, or I'm sorry, within 2 weeks or a month after that last thing that the tenant is supposed to do under the agreement. So that way it's dismissed as soon as possible. It's not staying open on a tenant's record. The other thing we often will advise tenants to do is, especially if you're agreeing to a move out date in a stipulated agreement, because it's also not uncommon for tenants to say, I'm moving out, I just need an extra 3 weeks, I need an extra month. And so the stipulated agreement simply just allows for a later move out date, is ask that the landlord immediately dismiss the case with the right to reinstate. And this, I know, sounds very lawyerly and like, you know, jargon. But what's important about that is that if you have the eviction case open on your record while you are looking for new housing, it's going to be very, very challenging to find a new place to live. So the benefit of saying to landlord, hey, if you immediately dismiss this case now, we have this agreement, it's part of the court record. If I don't follow it, you can go back to court and reopen the case. That way it gives the tenant a dismissed eviction on their record, so the landlord will not hold it against them while they're looking for housing. If you have questions about that, feel free to email me, we can chat more about it. So really, really important that nobody should ever agree to an agreement that they cannot follow, because it's the quickest way to get an eviction on your record. You're not doing yourself any favors. So if the tenant doesn't comply with the agreement, the landlord can go back to court, file a document called a declaration of noncompliance, which basically says, we had an agreement, tenant didn't follow it, here's what they did that, or what they didn't do. And then the judge immediately gives the landlord a judgment of restitution. So gives that landlord the eviction judgment against that tenant. The tenant can basically ask for a hearing and say, wait a minute, I did comply with the agreement, or the landlord did something that prevented me from being able to comply with the agreement. And depending on how that hearing goes, either the eviction judgment will be upheld, sorry tenant, you didn't comply, or they'll say, okay, fine, you did comply, so we'll go ahead and dismiss this eviction, but we keep the, you probably keep the stipulated agreement in place. It's been my experience that judges have less patience around these hearings for noncompliance. I don't see those often going in favor of the tenant. So really, really important to make agreements you can keep.
All right. So like I said, this is going to be a 3-part presentation. So the next portion of this, part 2, is the expungement of eviction records. So we just went over the eviction process. What happens when worse comes to worse and you have an eviction on your record. Luckily now in the state of Oregon, there is a mechanism through which tenants can get these FEDs on their records completely erased. Basically, they're treated as if they never happened. So yeah, thanks to Senate Bill 873, as of January 1st of this year, we now have that process. And this is important for a variety of reasons, obviously the most obvious of which is it addresses a significant barrier to housing, right? And I mean, this applies to all folks that have had an FED filed against them, not necessarily just people that have lost, whether it be because they, came to a stipulated agreement and, failed to comply with the terms of that agreement, like Christina mentioned, or, it went all the way to trial and they lost there. Even tenants that, get cases dismissed in their favor are affected to some degree in some cases, right? So previously I mentioned that landlords in Oregon under Chapter 90 are prohibited from considering, cases that, FEDs that were dismissed or resulted in a general judgment for the tenant during the application process, right? Those aren't factors that they should be considering, nor should they be a reason for denial. That doesn't mean that landlords don't consider them, unfortunately. Landlords are sometimes very clever. They're good at finessing their way around the law. And if they're smart and, they have a problem with the fact that a tenant had an FED just filed against them, not even that they lost, they might find a creative explanation for why they're actually denying that tenant. So they might say, oh, it was because of your credit, or the landlord gave a bad reference, I don't know, something that they would make up. So this new mechanism helps to address that, right? So that's never a concern. It's not something that'll show up on a tenant's record. So now I'm just going to go over who's eligible. So not all eviction records can be expunged. An eviction can be expunged if, 1, the final court judgment is at least 5 years old, and the tenant does not owe any money that was included in the judgment. This kind of uses those prohibitions that I've already kind of discussed under Chapter 90 about what landlords can and can't consider. Those kind of like motivate what makes a tenant eligible to have their FED record expunged. So like I mentioned, previously, they can't be considering FEDs that were dismissed or resulted in a general judgment for the tenant. They also can't be considering evictions that are older than 5 years. So this helps to eliminate those so that it's impossible for them to be considered. The second way that a tenant is eligible is if that tenant made an agreement in court, so stipulated agreement, and the tenant complied with all the terms of that agreement, including paying any money owed. So, obviously we think that the most that the court will do to investigate whether or not that was the case is just kind of go back into the court records and check whether or not a declaration of noncompliance was ever filed by the landlord, indicating that, the tenant failed to comply with the terms of the agreement that they signed. And then the last way that a tenant is eligible is if they just straight up won the eviction and the eviction was dismissed, right? Whether before or after trial. So those are the ways that somebody is eligible. So it's a pretty easy process for the most part. I mean, we haven't really run into too many issues in the few that we've filed. So right now the courts have a pro safe form, which I will show you guys in just a second. It's called the motion to set aside residential eviction judgment. So that's kind of like step one in this process, right? Is the tenant needs to fill that form out. It's pretty basic. All it asks is for the name of the tenant, the name of the landlord. It asks when, the eviction record was, the eviction was dismissed, or when the judgment was entered into, just to make sure that, the tenant is obviously eligible. And then there's like basically a checklist, including those 3 reasons that were on the previous slide. So the tenant has to check off how they're eligible. So, if they had a dismissal in their favor, that's what they would check off. If they, signed a stipulated agreement and complied with that, that's what they would check off, et cetera, et cetera. And so once that's filled out and filed with the court, the tenant is then responsible for serving the landlord. So they have to mail a copy of the form to the landlord in the eviction case. That to me might be the most difficult part of this whole process. I've recently had my own landlord tenant issue, and serving them was a pain in the butt, because some landlords hide under a million different LLCs and stuff like that are very difficult to identify. So for that reason, that's one of the reasons that we're open to helping tenants out during this process. I mentioned that it, to me, seems like a simple process. That doesn't necessarily have to be the case for all tenants. So we're happy to help people out. Again, I'll share my contact information at the tail end of this presentation. I welcome people to, reach out. We can kind of talk through things, see if tenants are eligible, and then hopefully hook you up with a housing attorney who might be able to help you guys get these filed if need be. So yeah, step 2 is serving the landlord. Step 3 is, so basically the landlord, once they get it, they have 30 days from the date that the tenant mails the form. They have 30 days from that date to object to the expungement. So we can't really think of very many reasons why it's, a landlord would want to do this, especially for some of these older evictions. But presumably, if there was a money judgment as part of that eviction that the tenant still hasn't paid off, this would be the time where that kind of comes up, is, through this objection. So I'll also show the objection form in just a second, so that people can see what it is, what information would be asked of the landlord, basically. And then the last step is it's basically 2-pronged. So if the landlord files an objection, the court will schedule a hearing at that point, and will decide after the hearing whether or not the tenant is eligible based on whatever information the landlord may have provided. But conversely, if the landlord does not file an objection, the court will rule on whether the record is eligible for expungement. So that's kind of, where we're not really sure how in depth the court will get into, looking into whether or not for example, whether or not a tenant came into compliance with a stipulated agreement. If there's not a declaration of noncompliance filed on there, we think that might be enough in such a case for the judge to just say, okay, it looks like you're eligible. Yeah, because presumably, if no declaration of noncompliance was filed, the tenant must have complied, right? So, so yeah, those are the 4 steps in my long-winded fashion I typically deliver things in. So this is the motion to set aside. So this is basically the form that starts it all, the pro se form that the courts are making available for tenants. So again, very basic. There's that checklist basically where tenants have the opportunity to check off how they're eligible. And then in the back is that certificate of mailing, just kind of verifying that they, serve the landlord. And then this is the objection form that the landlord would submit to the court, filed with the court, if they wanted to object to the expungement. So yeah, that's the basic premise. And one thing that I forgot to mention at the beginning of this is if anybody has any questions, I know it's a ton of information to take in, feel free to just type them up on the chat feature. I've been kind of taking a look at it to see if anybody has. So far, no questions, but yeah, feel free to hit us with questions through there. And if Christina has nothing else to add, we can move on to some of these eviction updates, in relation to COVID-19.
Yeah, the forms, if folks do want to use the non-attorney forms, they're on the Multnomah County Court website. So if you just type Multnomah County Circuit Court forms, I think it will come up. It's the courts.gov, whatever website. Those forms are on there. If you hit evictions, then you'll see it's setting aside an eviction case. You know, I've done about 5 of these now collectively in the office. We've done a bunch, and no, we haven't had any landlord object. I think as long as we screen them and, you know, as a tenant, if you're eligible or not, if you're eligible, I see no reason why a landlord would ever object to it. The only hiccup, I think, like Mateo mentioned, is if there is some money owed. So if you either agreed to pay your landlord money and you didn't pay it, or you agreed to pay the landlord's attorney money and you didn't pay it, that may not necessarily be the basis for them to file a non-compliance, depending on how it was drafted in the stipulated agreement. So that could be a problem. The other thing is if you actually lose the eviction, but it's over 5 years old, if you didn't end up paying the court costs or attorney fees for your landlord, you wouldn't technically be eligible, and that may be a basis why they're saying they would object, but we haven't come across that yet. And so in light of COVID-19 eviction updates, which we're going to talk about, but courts are kind of on pause right now. So if folks are filing these eviction expungements, they are still accepting them. The courts are, if you mail them in, but they're not really doing anything with them. So I don't think we're going to see them ruling on any of these requests probably for some time. Courts aren't going to open again until the summer, and then there's going to be like a whole snowball effect of all the work that was not being dealt with while they were shut down. So just a word of caution on that. It's a great remedy, but I think right now it's kind of not going to be an immediate remedy for a bit of time. So talking about the COVID-19 eviction updates, we want to make sure folks know what's happening with evictions, what folks' rights are to not pay rent right now, or defer paying rent, or pay partial rent, given that, you know, the world is a bit upside down. So there's a few levels of protections. There's statewide protections that were by the governor's executive order. Then Multnomah County did their own protections, and then the federal government did certain protections for subsidized housing. So we'll kind of talk about each, and they overlap in a lot of ways just to make it extra confusing. So in terms of statewide, effective April 1, the governor made basically an executive order saying that no landlord can give a termination notice for non-payment of rent, fees, or utilities, or any other financial charges that they may normally have given a tenant until June 30th. So from April 1 to June 30th, no tenant can be getting a non-payment of rent notice, a termination notice. They also cannot charge a tenant for late fees if they don't pay their rent on time from April 1 to June 30th. They can't start an eviction case based on non-payment. So if say there was a notice that was given for May's rent, but they hadn't filed it yet for some reason, they can't file it after April 1. And that they're not going to also allow sheriffs to enforce these agreements, to enforce judgments of eviction as well, if it's based on non-payment of rent or no causes. So what's interesting is that the language of the executive order says no cause notice, but what it references is the section of the law that talks about those 3-strike notices and the landlord reason notices. So we think there's a legal argument that they can't give those kinds of notices right now as well under this eviction moratorium. So think a more expansive definition of no cause. It's both landlord reason, and it's potentially also the 3-strike notices. But landlords can still be giving, you know, your other kinds of 4-cause notices for lease violations that are unrelated to the payment of money. The executive order does say that the tenants should notify their landlord if they're going to be unable to pay as soon as possible. There's no requirement that it has to be done before rent is due. It's just as soon as you are able to. And it also says that tenants should pay as much rent as they are able to pay. You know, I don't see how that's really going to be enforceable. You know, everybody's finances are different. You know, people are having to spend much more money on other things right now. And so if there's some extra money in your pocket to pay rent, go ahead and pay rent. But, you know, landlords shouldn't be hustling or shaking you down to pay the rent. The one thing that we have been seeing that I want to kind of flag is we've seen a lot of landlords or hearing rumors of landlords saying, oh, we heard you got that stimulus check. Why don't you go ahead and pay that over to us and rent? You know, you don't have to do that. That's illegal. So if you can pay it, great. Because what's going to happen is, you know, come June or come later, if you live in Multnomah County, all that rent is going to come due, right? And so for some folks, if you made partial payments along the way, that will reduce the total amount you owe, and that may make it easier for you. For others, that's not their financial situation, and it will not make it any easier. So you know your financial situation best. And so in addition to the governor's order, the Chief Justice of the Oregon Supreme Court made an order that applies to all the courts in the state of Oregon that basically says there will be no court eviction hearings until after June 1, 2020. So even if there was a pending eviction case for an issue beyond non-payment of rent for some other type of termination notice, a for-cause termination notice for behavioral issues, those are all on hold. There's gonna be no court hearing scheduled until June 1. The only exception is that there may be the ability for a landlord to make a specific request to the court to allow them to move forward on a 24-hour notice for a really extreme type of eviction, if it's really extreme behavior that the tenant engaged in. And that's, the court has to permit it on a case-by-case basis. So it's not like a flat, any 24-hour notice case gets through. It has to be an individual determination by a judge. And this applies to all evictions that were filed after May 18th. That's when, March 18th. That's when the Chief Justice's order went into effect. And so the executive order, I kind of already briefly mentioned this by the governor. She updated it and basically said that no law enforcement can remove tenants from their homes if there had been an existing eviction order that went into effect prior to her prior executive order, if the non-payment was based on rent or termination without cause. And I think what we're hearing is that the sheriffs aren't necessarily assessing what the underlying eviction was. They're just not enforcing evictions right now because they don't want to be the one making the call about looking through the court record to see if it was non-payment or rent, because the documents they get is just a writ saying, hey, cause this, you know, you need to remove this person. So I don't think any evictions are being enforced right now at all. And that's in place until June 20th. So there's kind of, right, so there's some staggering timelines in terms of June for the court, June 20th, June 1st for the courts, June 20th for sheriffs. And then Mateo's going to talk about the Multnomah County specific protections as well.
Yeah. So yeah, Multnomah County basically just very recently actually updated their protections for tenants, kind of brought them a little bit more in line with the governor's more recent executive order, and actually further expanded on it. It's a lot more pro-tenant, fortunately. So yeah, right now in Multnomah County, there's a temporary ban on evictions based on non-payment of rent and utilities and fees, similar to, you know, that executive order, right? The thing that Multnomah County did, though, is that there's no requirement that tenants prove that they have lost income due to COVID-19. There's also no sort of like deadline for them to make a landlord aware of this. So like, for example, under the executive order, I think it's like, on or before the first day that rent is due. That's not necessarily the case in Multnomah County anymore. So this is going to last up until July 9th, 2020, unless it's, you know, obviously revised and then further extended. And then very importantly, after July 9th, tenants are going to have an additional 6 months to pay back the rent and utilities that built up during the state of emergency, all that rent that they were unable to pay because of a loss of income due to COVID-19 that built up. They're going to have 6 months to pay it back. So I believe that it's going to be sometime in January or something like that. That they're gonna, that's like the deadline for them to pay it all back, right? And landlords can't charge late fees during the state of emergency. Obviously, again, no notices of termination, none of that. No, basically taking no step towards evicting tenants for non-payment. All eviction hearings in Multnomah County have been postponed until at least June 1st, 2020. So again, kind of in line with that Chief Justice order that Christina just discussed. And that's regardless of whether or not they're based on non-payment of rent or something else. So that's compliant with the Chief Justice's order. If the court has already issued a judgment of eviction against a tenant and the eviction was based on non-payment of rent, the Multnomah County Sheriff will not enforce any eviction judgments that have not yet been carried out. And like Christina just mentioned towards the tail end of her, that last slide, the indication we've gotten from sheriff's departments is that regardless of the reason for the eviction, they're not enforcing any writs for the time being. I know that I personally spoke to several representatives over at the Multnomah County Sheriff's Department, and they all assured me that, yeah, they're not enforcing any, they're not kicking any people out of their homes during the state of emergency. So that's encouraging. I hope that that's the case statewide as well. And then another thing that this Multnomah County ordinance is doing is, giving tenants the opportunity to postpone their rent payments in Multnomah County. So until July 9th, 2020, tenants who have experienced a loss of income can postpone those rent payments and or payments of utilities or fees. Again, this doesn't necessarily waive their obligation to pay them. They're just building up in the meantime. And again, they're going to have those 6 months afterwards to, pay off whatever was accumulated. So that was the deadline that I was previously mentioning. So tenants basically have until January 10th of 2021 to pay back any postponed rent, utilities, or fees that built up during that time. Tenants should notify their landlords in writing that they will be unable to pay rent, utility, or fees, whatever that may be, as soon as possible. But again, there's no requirement that tenants have to provide documentation proving that loss of income was related to COVID-19, nor is there that deadline that existed in the previous ordinance that Multnomah County had. If possible, tenants, are responsible for paying as much of the rent as they can afford to in light of all their expenses. It is important that it's not, our prediction is that it's not going to be uncommon for landlords to refuse partial payments, unfortunately. So if that's the case, we definitely encourage tenants to, keep written records. If the landlord refuses partial payment, just keep, a record of, these attempts to pay, and of the fact that, that payment was refused by the landlord. I think that's going to be pivotal. And then, like Christina mentioned, federally, the CARES Act imposed protections for, tenants in subsidized housing. So I kind of, there's a more specific list of, what qualifies as, federally subsidized housing. But I mean, in general sense, it's, if a tenant is getting any sort of assistance on rent or, any sort of reduced rent, there's the possibility that they would qualify under this. So public housing, so HUD housing, tenants in low-income housing tax credit buildings, tenants with housing choice vouchers, usually know who they are, so they should be able to identify themselves. Tenants that live in Section 8 project-based voucher units, housing for elderly and disabled tenants, rural development housing, all of that. And basically what the CARES Act does for subsidized housing tenants is it prohibits landlords of any of those kinds of properties, right, from doing any of the following during until July 26th. So they can't, issue new notices of termination based on non-payment of rent, fees, or other charges. They can't file a new eviction case based on non-payment of rent. I thought there was another slide for that, but I guess it's that simple, guys. I thought there was more information, but yeah, basically in essence, they can't in any way try to move forward, interfere with a tenant's right to possession of the premises during the state of emergency, right? If it's for non-payment of rent. So as Christina noted, there are currently no protections for tenants who are getting termination notices for other reasons. So it's something to keep an eye out, right? Because there's a possibility that, desperate landlords are just going to try to issue termination notices for other reasons, try to BS their way into getting, tenants out of their housing secretly for non-payment. But, if they're smart, they're going to try to finesse it and make it seem like it's for another reason. So it's definitely something worth keeping an eye out. If you as a tenant are getting a termination notice that, seems fishy, obviously feel free to contact us. And on that note, there's our contact information again. I did promise you guys my Google Voice number. I thought I had updated the slides to include it, so I'm just gonna have to say it verbally. So for anybody that, I'm actually gonna put it in the chat as well.
So,
And I think we have some questions as well too.
yeah, so Rooted Black asked, what if the landlord requests a documentation? And that's a really good question. And here's, I think, where it gets confusing. So when the Multnomah County ordinance was initially passed, it did require documentation. But then Multnomah County changed their ordinance as of April 16th and made it retroactive to when it was initially passed. So there was a brief window of time for, like, I don't know, what was it, 2 weeks,
Yeah.
where a landlord could ask for documentation, or maybe it was 3 weeks. And so that was okay at some point in time. It's not okay anymore. There's no requirement that the tenant provide documentation. And so I don't know, we're happy to chat with you more, Rooted Black, if it's still a kind of an ongoing issue and they're still, you know, giving you slack about it if you say, oh, you know, I don't need to provide documentation any longer. And so the other thing we're seeing a lot of is landlords wanting and pressuring a tenant to enter into a payment plan. So they kind of start paying off that deferred rent payment over time. There's no requirement in the ordinance. And the ordinance was actually specifically changed on April 16th to say, not the best language, I wouldn't have written it this way, but it basically says nothing in this ordinance requires or prohibits a landlord and a tenant from entering into a repayment agreement. So clearly you don't have to enter into a payment agreement if you don't want to. There's really no benefit to entering into a payment agreement because you don't, I mean, not, you know, finances change, right? Like, who knows what tomorrow's going to look like. So I think it's generally a good idea to not enter into a payment plan. The downside of not agreeing to some kind of payment plan with your landlord is that landlords are not going to accept partial payments for reasons about other kind of wonky landlord-tenant law, that they don't want to waive their right to terminate for non-payment if they've accepted a partial payment of rent. So landlords may not be willing to accept partial payments without some kind of agreement in place that says, we're accepting this partial payment because, you know, we're agreeing that we can still evict you otherwise, and you're agreeing to that too. So for some tenants, it's better just to wait the 6 months and just pay it all when you have it and be done with it. For other tenants, it's better to pay a little bit as you go, just depending on how your finances work. But nothing is requiring you to enter into a payment plan or to provide documentation. And you have 6 months till January 10th, unless it's otherwise. Wait, I should look at the date. It was in the beginning of January. Is it 10th or 9th? Anyways, look at the slide.
January 10th, yep.
Don't listen to my vague memories. To pay it all back, but it is all due back at that time. So if you don't pay it all back, they could then turn around and give you a 72-hour notice for that whole whopping amount of rent. Any other questions that anybody has?
Hey, yes, y'all. Thank you so much for your presentation. I actually have a question. So Executive Order 2013 is for the whole state, right? But it seems like Multnomah County did their own ordinance. What about the rest of the counties? Is there any information about what people are supposed to do after June 30th? Like, are other counties going to get payment plans as well, or 6 months, or like, what does that look like?
I don't know. So so Gresham did something. I mean, they're covered by the Multnomah County plan as well, the ordinance as well. But they did something super interesting, which basically said if a landlord violates the Multnomah County ordinance, they will take away their licensing agreement, like their ability to rent property. And then I saw a video of the Clackamas County commissioners basically stating that they were doing a similar ordinance, but I haven't seen the ordinance on paper, but it was identical in terms of I think it was pretty much the same as Multnomah County, but as far as I know, it hasn't been actually like become written law. So I can't speak to whether it currently exists or not. So, and I'm not aware of any other jurisdictions or areas that has taken on kind of a deferred payment window like Multnomah County has. I think they're just going by the states.
Looks like we have a question from an Olivia as well.
Yeah. I don't know about that. I know that there has been talk about trying to do something on a state level, and it does not sound promising. That's been the rumors I've heard. And then, you know, obviously there's some federal buzz about trying to do something. And I'm not aware if it's going to make headway or not. Yeah, you're welcome. Yeah, I wish we could get some more clarity on that and soon. But the people in Salem that do, you know, work that kind of addresses tenants' rights issues have said it doesn't seem likely that there's going to probably be much happening in terms of opening up and doing a quick sort session to deal with COVID related stuff on a state law level. Any other questions?
Just so folks are aware, hidden deep in the chat now is my Google Voice number for anybody that needs it. Again, if you guys have any, you know, COVID-19 related housing issues that you guys want to talk about, I'd be happy to, you know, have a call with you guys. Christina just shared our website as well, which includes some handy self-help guides, both for just landlord-tenant issues in general, as well as COVID-19 specific stuff as well.
Yeah, and we're happy to chat with folks if your landlords are trying to pressure you to provide documentation or do payment plans. We'd love to talk with you. If you do want to apply for an eviction expungement, knowing that that's probably not going to happen for some months down the road, but we're also happy to talk to you about that and assist you in filing those papers.
Awesome. And if people wanted to go through the expungement, do we need to, because we have this video, we'll be able to share this information. So should we leave your information in the comments of the video for contact, or should they go through our intake process through Don't Shoot?
I mean, you could share my Google Voice number. I have no problem with that. Yeah.
Okay.
And, yeah, folks could just leave me a voice message on there expressing interest in having an eviction record expunged or something along those lines. Yeah, just a brief description of the issue, I guess.
Awesome. All right. So how's everything been going for y'all as far as, you know, everything with the, you know, doing things virtually as opposed to being able to have people? Because one of the issues that I had was because we have the legal referral service, just even doing the intakes with some type of, you know, privacy for people. Did you have any kind of tips for us on that, or should we just start referring people to you? And then what type of bandwidth do you have? Do we, you know, should we, like anyone that wants to get in contact with you, how do we let people know what the qualifiers are for right now? Like, is there a certain amount of time it takes for you to get back to in contact with people, or are you pretty much available all the time?
I don't know if Christina wants to hit on that first. I mean, I know that I'd certainly have some bandwidth to, you know, screen tenants. Again, you know, there's never any guarantee that we're going to be able to provide help. Hence, you know, the idea of screening them first. But I'm always happy to speak to tenants. I have time. If I can't get back to them immediately, you know, I can certainly promise that if they leave a voice message, I will do so as soon as possible. So, yeah, I mean, if anybody outside of this presentation needs help, you know, they can either go through, you know, the intake mechanism that we've been using, whereby you guys just send me an email with a brief description, or they could just call me directly and leave a voice message, and I can just kind of go from there. Either way works for me. Yeah.
Thank you.
Yeah, most definitely.
And yes, we'll have this, this program is being recorded. We'll transcribe it. Most of the slides had the information that was being shared. So that information will be on our YouTube page, and you can get more information about upcoming workshops and different events that will be virtually available through Don't Shoot PDX. You can go to our page, don'tshootpdx.com, to check it out. Sign up for the newsletter. We'll be sending this out in the newsletter. Thank you, Christina and Mateo. We really appreciate this, especially during the pandemic. This is very useful information to a lot of people that might be in stress. So we'll make sure to get it out to a lot of networks.
Yeah, wonderful. Thank you so much for letting us come and chat with you all, and I appreciate the opportunity.
Yeah, thank you for setting all this up. I really appreciate it.
Thank you.
All right.
Thank you.
Thank you to everybody joining in. Thank you, Fendi, for putting all the work together.
Oh boy, y'all the best.
Yeah, most definitely.
All right.
Which I love this way better. Maybe this will be how we do things in the beginning.
I was thinking the same thing.
Except for our people at some of the different housing units. We still have to make sure that we figure out a way to connect with them, because they're like on AOL, dial up in regards to technology. So
Yeah.
that's the only thing that I'm worried about. So I'll make sure that this is available to them as well.
I appreciate that. Thank you.
Perfect. All right. Until next time, everyone.
Bye.
Bye.
Bye, y'all. How do I stop it? Okay. End the meeting.